What if justice didn't stop at one courtroom? What if after being extradited to one country, standing trial, and even serving a sentence, you could be sent again, and again, and again? Not because you committed a new crime but because the law never said no one else could try you. This is not fiction. This is not a loophole theory. This is re-extradition. And right now, that legal mechanism is sitting at the heart of one of the most consequential legal battles in Guyana's modern history. A case that could redefine extradition law. A case that tests constitutional protections. A case that asks a terrifying question. How many times can a person be put on trial for the same story? You're watching Global Sightline. And today, we're unpacking everything. Number 1. What this case is really about. At the center of this legal storm are Azruddin Muhammad and Nazar Muhammad. They are wanted by the United States on criminal charges related to alleged gold exports. But this case is not just about the US because the allegations stretch far beyond American borders. Gold shipments allegedly passed through the United States, Dubai, potential European transit points. And that detail changes everything. Because in international law, every country touched by a transaction can claim jurisdiction. That means multiple prosecutors, multiple courts, multiple trials, and potentially, multiple extraditions. Number 2. What is re-extradition? Let's slow this down, because this is the core issue. Re-extradition is a legal process where a person is extradited from country A to country B. The legal process in country B concludes that same person is then extradited again from country B to country C. This is legal unless explicitly prohibited. And here's the problem. Guyana's laws do not clearly prohibit it. The Guyana-US extradition treaty does not clearly prohibit it. That silence is dangerous. Because silence in law is permission. Number 3. Why the defense moved early. The Muhammad's legal team deserves credit. They identified the threat of re-extradition before the extradition happened. Because once a person leaves Guyana's jurisdiction, Guyana's power to protect them shrinks dramatically. Their argument is strategic and simple. If Guyana extradites us without ironclad protection, the state may be violating our constitutional rights. This isn't emotional lawyering. This is preventive law. Because once the door opens, you can't close it from outside. Number 4. The constitutional question. Here's where this case becomes historic. Guyana's constitution guarantees due process, protection from arbitrary punishment, fair legal treatment. The defense argues that extradition without protection against re-extradition creates a legal chain with no endpoint. One trial becomes many. One extradition becomes several. And the Constitution was never designed to allow a citizen to be passed from country to country like cargo. If extradition exposes someone to indefinite prosecution, is that still justice? Or is it punishment without limit? Number 5. The Fugitive Offenders Act. The law governing extradition in Guyana is the Fugitive Offenders Act. It operates in conjunction with extradition treaties. But here's the issue. The act does not explicitly block re-extradition. The treaty with the US does not explicitly block re-extradition. This creates a legal vacuum. And in that vacuum, anything can happen. The defense says this gap makes the entire process unconstitutional. Because constitutional rights should not depend on trust, they should depend on law. Number 6. Government steps in. Attorney General Anil Nandlal responded forcefully. He insists that re-extradition will not happen in this case. Why? Because the United States provided a diplomatic assurance. A formal note promising that after the U.S. proceedings end, the Muhammads will not be extradited to any other country. According to the Attorney General, this satisfies Guyana's legal and constitutional obligations. The government says, due process was followed. Rights were respected. Safeguards were obtained. Case closed. Or is it? Number 7. Why the defense does not trust it. Senior counsel Royce Dale Ford strongly disagrees. His position is grounded in precedent. Courts have ruled before that diplomatic assurances do not override legislation. If a protection is not written into the treaty, it has no legal force inside Guyana. A diplomatic note is a promise, not a law. And promises can be broken. Governments change. Administrations change. Geopolitics change. But extradition, once done, is irreversible. Number 8. The trust dilemma. This case forces an uncomfortable question. Should citizens rely on written law or diplomatic trust? Because once a person is in foreign custody, Guyana has no enforcement power. If another country requests extradition later, Guyana cannot intervene. That's why this debate matters. Not just legally, but morally. Number 9. Why this case affects everyone. Today, the names are Muhammad. Tomorrow, it could be anyone involved in international trade, banking, shipping, travel. Globalization means shared jurisdiction. If Guyana sets a precedent that diplomatic assurances are enough, then the law itself becomes secondary. And once precedent is set, it doesn't stay contained. Number 10. Final thoughts. This is not about guilt or innocence. This is about how far the law can stretch before it breaks. Should extradition come with permanent legal safeguards? Or is trust between governments enough? That's the question this case forces us to answer. And your voice matters. Drop your thoughts in the comments. Share this video. Start the conversation. Because this case may redefine extradition in Guyana and beyond. This is Global Sightline. Stay informed.